First of all, looking around the room, there are plenty of familiar faces, but for those of you who don't know me, I'm Hayden Glynn. I'm a property litigator at Lupton Fawcett Solicitors in Leeds. We're one of Yorkshire's top 10 law firms. We specialise in all areas of law, and we have offices across Leeds, Sheffield and York. I work out the Leeds office, and across those three offices we employ in the region of about 300 staff, half of which are lawyers. What I do, I personally head the residential property litigation team, and we specialise in resolving both residential and commercial property-related disputes for a wide range of clients, from individual clients with perhaps one or two residential properties who simply rely on those properties to supplement their income, to large national corporate property companies with huge portfolios. We also do a lot of work with developers and surveyors, and also work very closely with lots of the banks and building societies. But what I want you to appreciate is, no matter how big or small your portfolio, the problems faced by residential landlords these days remain the same. Now, I appreciate in this room there are probably many seasoned, savvy investors, and therefore you may already have certain measures in place to protect against the certain types of issues I'm going to talk about. But for those who don't, please, it's very easy to overlook these issues. You've already heard from Mark Manning and Pete, who tell you that the outlook for buy-to-let landlords is generally positive. Demand for rental property is expected to stay high, which in turn will continue to push up rents. That coupled with low interest rates, it really does make it the perfect time to be a buy-to-let landlord. But the problem is I see so many landlords who are not taking advantage of the opportunities available to them and foolishly leave themselves exposed to serious issues that can significantly dent their profits. Now, I assume everyone in this room is interested in maximising their rental return. If you are, and as Pete's already touched on this, something I always tell all of my landlord clients, it's very, very important that you always treat property as a business, never a hobby. I always say a systematic business-like approach separates the personal from the professional. A casual, haphazard approach will always cost you. So what I wanted to do was go through some of the most common issues that my team and I see faced by residential landlords, and hopefully try and explain to you how best to either avoid them altogether, or if they are unavoidable, how best to minimise the impact of those issues on your business. So as a team, we're most commonly instructed by residential landlords to 1, pursue tenants and guarantors for arrears of rent, to issue possession proceedings, to defend disrepair claims brought by tenants, and also to deal with tenancy deposit issues. So if I just I'll go through each one in turn. First of all, how best to avoid rent arrears. I always say prevention is always the best cure. Now, it's very easy to assume that certain types of property and certain types of tenants are more likely to lead to rent arrears. But the reality is housing debt affects all walks of life, all individual circumstances, and that's why it's so difficult to predict and subsequently avoid. But there are certain steps that you can take to minimise or reduce the risk to your business. The first, taking precautions before granting a new tenancy, is key. But again, if you instruct Mannings to let and manage your properties, you needn't be too concerned with these points, because as a matter of course, Mannings will carry out these types of checks. So for example, vetting prospective tenants thoroughly. That might include obtaining income, proof of income, employers' references, former landlords' references, that type of stuff. You should always be considering whether or not there's a policy of insurance that you're able to take out to protect against unpaid rent. Consider whether or not there's a guarantor available, whether or not there's anybody that's willing to guarantee the obligations of that tenant. And if there is, best practice is to assume or to ensure that that guarantor is UK-based and preferably a homeowner. That will give you the best chances of recovery should you need to ever go down that route. Always take a deposit and advanced rent, and I always say also insist on a tenant setting up a standing order to pay the rent. I've also put keep the lines of communication open. I don't think there's anything wrong at the outset of a tenancy saying to your tenant, look, I hope you'll pay your rent on time, but if you're ever going to be late, you must notify me. Tell me in advance. Don't just bury your head in the sand. Don't assume it will go unnoticed. Hopefully those points I've just referred to will help you to avoid rent arrears, but if they are unavoidable, then there's a couple of points that you can try to implement that will minimise the impact of those arrears on your business. So first of all, reacting quickly. I always say it's crucial to react quickly. The moment you discover that your tenant has failed to pay rent, you must contact them and their guarantor. It not only helps to sort out the problem quickly, but it also sends out a strong message that you will not tolerate late payments and that you are on top of things. Also, factor in the potential cost. I always say one of the greatest ways of mitigating against the risk of rent arrears is to factor in the potential cost. I say generally as a rough rule of thumb, if you assume that you will only receive rent 10 out of 12 months of the year, that allows you to absorb any unexpected costs or moderate late payments, so you can plan your investment around that. Also, if your tenant's circumstances change, then you need to be looking as to whether or not there's an opportunity to negotiate an early surrender of the tenancy. But if there isn't, and your relationship with your tenant genuinely has broken down, then you must issue court proceedings to obtain possession immediately, because the court process can take several months, and money is obviously, time is money in this business. So moving on to possession proceedings, as I say, if your relationship with your tenant has broken down, you issue court proceedings immediately. But before you do, I just want you to remember a couple of points. First of all, there's a strict statutory procedure that you must follow. That starts with the service of notice on your tenant, whether that be a Section 8 or a Section 21 Housing Act 1988 notice. That's the first step in the commencement of possession proceedings against your tenant. But what you must bear in mind is if that notice is either incorrectly prepared or wrongly served, it will be invalid and you will not be entitled to possession of your property. Assuming you do serve a valid notice on your tenant, if that notice expires and your tenant has still failed to vacate of their own accord, then you must issue court proceedings, because the only way that you can lawfully evict a tenant in England and Wales is through first obtaining a court order. Never just change the locks to the property. If you do, you've unlawfully evicted your tenant, and I've acted over the years for numerous landlords who have foolishly unlawfully evicted tenants and found themselves very quickly on the wrong end of significant compensation claims. I've seen them run to tens of thousands of pounds. Again, I've just reiterated, act quickly, as the court process can take several months. So moving on to how best to avoid disrepair claims. Again, as a team, we are regularly instructed to act for landlords who are being pursued for compensation by their tenants for disrepair. Again, in severe cases, I've seen significant windfalls go to tenants, and it's actually one of the most common reasons a tenant will ever give for having failed to pay rent. They'll say the property's in disrepair, so don't give them that excuse. But it's actually very easy to avoid ever being on the wrong end of a disrepair claim. But you'll be amazed how many landlords overlook their obligations in that regard. So I just thought it might be quite helpful if I very quickly just took you through a few points. So first point to bear in mind is that Section 11 of the Landlord and Tenant Act 1985 is implied into all assured short-hold tenancies. That's regardless of whether or not it's expressly written into the contract. There is an implied obligation in law on a landlord to ensure that, A, you keep in repair the structure and exterior of the dwelling. That includes the drains, gutters and external pipes. You keep in repair and proper working order the installations in the dwelling for the supply of water, gas, electricity and for sanitation. And you keep in repair and proper working order the installation in the dwelling for space heating and heating water. A couple of points to bear in mind. A landlord's liability under Section 11 of the Landlord and Tenant Act will not arise until you are on notice of that disrepair. But be warned, the notice does not need to be in any specific form. It could be written, it could be oral. Landlords have an implied right of entry and inspection. There is an implied entitlement for a landlord to enter their own property at reasonable times of the day on giving no less than 24 hours written notice should you ever need to. And once you have been into the property, perhaps investigated a concern or a complaint raised by a tenant, if it is a genuine justified complaint of disrepair, then you have a reasonable period of time within which to undertake the repair work. Now obviously, naturally, the bigger and more expensive that repair work, the longer would be reasonably expected to carry out that work. Lastly, fourth point, how best to avoid tenancy deposit disputes. Again, it's another area that my team are commonly instructed to deal with, and as Pete's already highlighted, since April 2007, landlords are obliged to protect tenants' deposits with one of the government authorised tenancy deposit schemes. You have 30 days within which to protect it from the date that you take that deposit, and within that same 30-day period, you must serve upon your tenant what's known as prescribed information. Information, for example, how the deposit's held, what will happen at the end of the term if there's a dispute, that type of thing. If you fail to do that, your tenant is entitled to issue court proceedings against you. They're entitled to claim from you the entire deposit back, plus up to 3 times the value of that deposit as compensation for you having breached the tenancy deposit regulations. And you should also bear in mind that if you haven't protected a tenant's deposit, then you will not be able to serve a valid Section 21 Housing Act 1988 notice, which, if you remember, is the precursor to having to issue court proceedings. And if you're evicting a tenant, going down the court possession route, if you're not able to follow the Section 21 route, it means you can't follow the accelerated procedure route. There will therefore be a more protracted way of obtaining possession. Assuming that you do protect your tenant's deposits, then data from the tenancy deposit scheme suggests that the most common cause of a dispute over the return of a deposit relates to cleaning, the state of cleanliness your tenant leaves your property, and also damage caused to the property. Bear in mind, deposit protection schemes, they have internal arbitration processes that you will have to be bound by and you'll have to follow. But what you must bear in mind is the onus of proving your claim is always on the landlord. It's for the landlord to prove that they are entitled to retain the deposit or an element of that deposit. It's not for the tenant to prove that they're entitled to that deposit back. So if you're unable to prove your claim, you will not be entitled to retain that deposit, nor would you be able to successfully sue that tenant through the county court for any loss that you might suffer. So what I always say, to protect your position, you must always have a professional inventory prepared pre-tenancy, but also a photographic schedule of condition that must be signed by the tenant. That way you can evidence or illustrate the state of the property at the outset of the tenancy. If you're trying to deduct monies from a tenant's deposit saying that they've damaged the property, you're going to have to be able to prove that that damage wasn't there at the outset of the tenancy. And if you can't, you won't be able to retain that deposit.